And we are fully there. So let's get started. And as you can see, there are a lot of words in my title today, and that's because I got a lot to talk with you about. And so a major Supreme Court decision was dropped in the middle of the last week, and this is the Louisiana versus Callais decision. Most people regard this as, at least most of the people I pay attention to, regard it as the final nail in the coffin of the Voting Rights Act of 1965. And by the way, the Voting Rights Act is often considered the crown jewel of the civil rights movement. I have some imagery from the civil rights movement on the board. And this occurs in a couple different contexts. The short-term context is one in which the President of the United States and his party have appointed 6 out of 9 members of the Supreme Court, and the President and his party appear to be deeply unpopular and likely to be punished in an election that is taking place for Congress in the next 6 months. The president is sufficiently alarmed about the prospects of losing control of Congress and potentially being investigated for misconduct and various forms of corruption that he has asked the states to redistrict in a very unusual way in the middle of a decade. And this is in order to, right, in a sense, prevent the electorate from punishing the president and his party for pursuing unpopular policies. And one of the impediments to parties maximizing partisan advantage in the process of redistricting is the Voting Rights Act. The Voting Rights Act imposes certain constraints on partisan gerrymandering, and the Supreme Court just removed those constraints effectively. And so the idea that this is an apparent effort to do two things at once. On the one hand, to confer maximal partisan advantage to one party at a moment when they most need it. And on the other hand, and more deeply, more importantly, frankly, to undo the legal and political effort to remove racial hierarchy in our society and racial inequality in our politics. And this is at a moment when the United States is becoming more diverse. And we can see, because it is rapidly approaching and already here in many places in the country, that we will, within, I don't know, a decade, 20 years at the most, become a country with no racial majority, in which people of European descent or white people will become the minority, not, right, a minority in the sense of being outnumbered by any other group, but just no longer the majority. And this is provoking, I'm sorry to say, fear, panic on the part of some people who believe that the greatness of this country, the culture of this country, the politics of this country, the tradition and ethics of this country have been sustained by it having a certain kind of racial composition, which is now being threatened by immigration and by demographics. And that I do believe the effort to, right, maintain white racial power is also one of the subtexts of this decision. And I want to be as clear as possible. Obviously, I don't believe Samuel Alito, who wrote this opinion, would say anything like I just said. I'm being quite critical and quite hostile in the way in which I'm describing the opinion. You can accuse me of being partisan. Clearly, what I say aligns with one, right, perspective on this decision. But I am, in fact, I hope, trying to do something different in what I'm saying to you, which is to think more concretely and in a more philosophical vein about what democracy means in a multiracial 21st century society. And so while on the one hand, I want to be very clear, I think that Callais, this decision that was reached in the middle of last week, Louisiana versus Calais, I think might be the right way to pronounce it, is going to go down in history as an extremely problematic Supreme Court decision, as one that is one of racial retrenchment, that undoes the legal instruments we had to remove some of the stain of racial hierarchy and inequality from our political process, and that therefore I think we are justified in criticizing the decision in harsh language. I will also then add that I don't think that that accomplishes very much, and that rather than feeding into a highly polarized political debate, yet more political gasoline, pour gasoline on the fire is not very constructive at this point. And so my effort today will be to talk more about whether or not there are things we could do to reconfigure our political process, and in particular our election system in the United States, so that it is fairer to all persons, so that it better institutionalizes responsiveness and accountability and the principle of one person, one vote, and frankly, to do so in a way that does not require as much attention to race or as much reliance on the Supreme Court. And so I want to share a analytic framework with you that helps to make sense of what I'm trying to do. I start with a book I like a lot by Philip Klinkner and Rogers Smith, two leading American political scientists, very interesting in their treatment of race. And in this book, The Unsteady March, they make an argument that there is a kind of rhythm, a kind of pendulum swing almost to issues to do with racial equality and justice in the United States, that there are circumstances in which we make progress in the struggle for racial equality and democracy, but they're very specific circumstances. Usually, they are in the aftermath of a large-scale war that required mobilization of African Americans both militarily and economically. And in particular, when Black soldiers come back from war, having risked their lives, having sacrificed their lives for the country, they are not as inclined to accept second-class citizenship. They have paid the highest sacrifice for their patriotism, and they want to assert their right to equality. However, by itself, that's rarely sufficient. Two other conditions are typically met. The first is that we're engaged in some kind of international competition in which the U.S. wants to emphasize its democratic bona fides, its inclusive, egalitarian, and democratic nature. I think the clear example here is the civil rights movement of the middle of the 20th century, in which not only had we fought World War II, Korea, and Vietnam, but we were also engaged in the Cold War, and we wanted to be able to say to countries in Africa, for instance, that we presented a better model for freedom than did the Soviet or communist model, but it's hard to do that while your police officers are clubbing Black people over the head, training fire hoses on them, sicking dogs on them because they want the equal right to vote, right? And so that created pressure on the United States to actually live up to its principles. And then the third aspect of this is that there is sustained domestic mobilization and protest. And on the cover of their book, they have one of these famous marches, right? And the idea that it's only when these three conditions coincide at the same moment that we tend to get progress toward racial equality in the United States. And these conditions did coincide in the middle of the 20th century, They coincided also in the aftermath of the Civil War, but that they are almost impossible to sustain for a long term, right? And so when these conditions are not sustained, racial retrenchment, the reassertion of white racial supremacy or black subordination typically follows. And I do believe that we should view this recent Supreme Court decision, Louisiana versus Callais, as the culmination of now decades long period of racial retrenchment in the aftermath of the abatement of the conditions for success. So that's the first piece of background. The second piece of background concerns the Supreme Court and the American Constitution. And I'm sorry, I have somehow covered over one of the words in my slide, but I've got on the board two contemporary legal scholars, constitutional law scholars, Nicholas Bowie of Harvard University and Erwin Chemerinsky of the UC Berkeley Law School, and the Chemerinsky is the dean. Bowie is one of the lead constitutional law scholars at Harvard Law today, and in different ways they are giving I think, very frank and very important assessments of where America stands in terms of its experiment with constitutional democracy. Bowie focuses on the Supreme Court, and he says in a widely cited law review article, Harvard Law Review from 2021, entitled Anti-Democracy, the following. The Supreme Court of the United States has an anti-democratic influence on American law, one that has undermined federal attempts to eliminate hierarchies of race, wealth, and status. He cites to a particular anti-union organizing case, Cedar Point, illustrates how the Supreme Court today is the ultimate supplier of anti-democracy in this country. The court controls how much democracy is allowed to exist everywhere in the United States, from Congress to the states, inside the workplace and outside. And yet, the court itself is currently undisciplined by any democratic procedure, right? It's an unelected, appointed institution. It has no mechanism of accountability, right? Because the justices are appointed for life. And by the way, because they're appointed by the president and approved by the Senate, it is accountable only to the two least democratically accountable institutions other than the Supreme Court and the federal government. And to be as clear as possible, what I'm talking about is the disproportionate influence of small states on both the Senate and the Electoral College, such that often the majority of the Senate represents less than a third of the people of the United States. So that's, I think, what he's referring to. In recent years, Congress has had little appetite to act as a co-equal branch of government with the legislative power to disarm the court and enforce its own interpretations of the Constitution. And I think this is particularly important in the context of the Voting Rights Act. So let me just supply a little bit of background here. The Voting Rights Act is passed in 1965. There's the famous, right, interaction between Lyndon Baines Johnson and Martin Luther King Jr. in the White House in the aftermath of the passing of the Civil Rights Act of 1964, in which King is invited to the White House to celebrate the passage of this legislation. And rather than dwelling on past victory, he points to future battles and says to LBJ, now it's time to pass the Voting Rights Act. And LBJ says back to King, make me do it, right? And so King, right, organizes demonstrations. People are battered by, right, horse-mounted police officers on a famous incident that's captured in film, and Congress rises to the occasion, passes the Voting Rights Act. But it is, frankly, the kind of legislation that can be circumvented by the states in certain ways, and it is weakened by the Supreme Court. And so Congress reauthorizes it in 1982, but they also amend Article or Section 2 of the Voting Rights Act, which gives citizens the right to sue and to get support from the Justice Department in their suits, and creates new and more powerful standards with which to detect the racist animus of fellow citizens. And so Congress had in the past been willing to do this work. It isn't willing or able to do it. It's too polarized. One of our two parties has drifted away from any real concern with racial equality. And so Bowie is pointing out, look, right, in the 21st century, we're saddled with a Supreme Court that is undermining what was left of our instruments for securing genuine democracy in the United States, whether that has to do with race, wealth, status. I might add gender, right? And you may have seen that there was a recent court holding Fifth Circuit, so not the Supreme Court yet, on the abortifacient drug methotrexate and access to it, which is going to make it much more difficult or maybe impossible in many states for women to gain access to it. Here's what Erwin Chemerinsky adds to the conversation. So, right, Bowie has suggested let's look at the Supreme Court and its role historically in the United States. The majority of our history, the Supreme Court has been an anti-democratic institution. Chemerinsky now focuses on the Constitution as such. The Constitution created a structure of government that was suited for a small, not wealthy country in which a tiny segment of white male landowners governed everyone else. Thankfully, we no longer believe that government is legitimate, but sophisticated political actors using powerful computers and social media that could not have been imagined in science fiction have figured out how to use the Constitution's undemocratic structure to create permanent minority rule, right? And so this refers to the Electoral College, the Senate, and gerrymandering, slicing electoral districts to disempower the majority from making its views felt. Beyond a spate of separate amendments, it's imperative after 200 years that Americans begin to think of drafting a new constitution to create more effective, more democratic government. And that's where I want to focus today, but not on a new constitution, on new electoral law. I've got a long way to go to get there, but I do think we need to start from the idea that our democracy is not working, that we're in a sustained period of racial retrenchment, that this is a fundamental betrayal of the promise of the Declaration of Independence, that all men are created equal. On, of course, the occasion of its 250th anniversary, it is equally a betrayal of the 14th Amendment to the Constitution, which provided the fullest articulation of the principle of political equality originally announced in the Declaration. So let's move to now the set of amendments that we sometimes call the post-Civil War amendments from 1865 to 1870. The 13th Amendment abolishing slavery, the 14th Amendment, the details of which we'll go into in a moment, the 15th Amendment prohibiting racial disenfranchisement. And I just want to say for a moment that we need to pay attention to the context in which these amendments were passed. They were passed in the aftermath of the North's victory in the Civil War, the result being that the Southern states were not, in fact, part of the Union at the time that the amendments were passed, and then it was made a condition on their readmittance to the Union that they endorse, embrace, ratify these amendments. So they were kind of forced down the throat of the southern states. And in order to make sure that the southern states complied, the Union Army continued to occupy the South, and we have a brief moment in the late 1860s, early 1870s, when there's movement toward full inclusion of African Americans in equal citizenship in the southern states. But this was politically unstable. Once the southern states were readmitted, northern citizens also began to tire of the struggle for full equality of blacks. It cost a lot, and it was polarizing to continue to occupy the South. And so, right, there was a famous political compromise in the Hayes-Tilden election, and the result was that the Northern troops were withdrawn from the South, and very quickly, right, there was rapid reassertion of racial hierarchy, supremacy, tyranny in the South. This is the long Jim Crow period. And so I want to focus in particular on the 14th Amendment and the role of the Supreme Court in this period. And so the 14th Amendment has 5 sections. Let me start with section 1, which will be subject to further Supreme Court litigation. There's already been an argument in the birthright citizenship case, and we anticipate that there will be a decision this term that upholds the plain language of the birthright citizenship provision of the 14th Amendment. But Section 1 contains more than that, right? That contains the idea that there should be no abridgment of the privileges or immunities of citizenship. In other words, equal citizenship for all, that all citizens should be afforded due process of law and equal protection of law. I think of this as the beating heart of the Constitution, the most important, the most democratic, the most egalitarian provision of our Constitution. It is therefore sometimes called the second founding, the time at which we finally put into the Constitution the principles that inspired the revolution and that distinguish America as a genuinely democratic, equal society. So the remaining provisions, I have a little bit of the language on the board. I'm going to just summarize very quickly. Equal apportionment by population, right? So the idea that each congressional district has to contain roughly equal numbers of citizenship, that within those districts, each person's vote should be equally valuable, as well as equally valuable across them if they're equally apportioned. And then I'll skip over the exclusion of insurrectionists, actually recently revitalized, but probably not active provision of the 14th Amendment anymore. But congressional enforcement is extremely important. And if we go back to, the first section, among the things that it does is that it makes the rights that are in the Bill of Rights effective in the states and not just vis-a-vis the federal government. And then the 5th section gives Congress the explicit power to enforce by legislation the provisions of the 14th Amendment. And please note, Congress does this in the 1860s with the Civil Rights Act that is still on the books and was one of the most important pieces of legislation to come out of the Civil War, but was rapidly dismantled or defanged by the Supreme Court. And so that's the story I want to tell just for a minute, because it seems to me to be relevant to the moment that we're in right now, as well as to how we assess the Supreme Court and the Constitution. So once, we get the Compromise of 1877, the Southern states are reincorporated, the support for Reconstruction is exhausted, the Southern states begin to reestablish racial tyranny, and the Supreme Court is very active in accommodating this by reading the 14th Amendment in ways that clearly violate its intent and its normative significance. So we get the slaughterhouse cases in 1873, in which it suggested that the 14th Amendment protects only the privileges or immunities associated with national and not state citizenship. So, yes, you can still vote in a national election, but if South Carolina wants to disenfranchise you in a state election, that's between you and South Carolina. We get the Cruikshanks case, in which, right, a mob slaughters a bunch of African American people who are protesting the theft of an election, and the right Supreme Court holds that the right 14th Amendment only entitles the federal government to protect African American civil rights against state action and not against private violation by mobs. And this is the beginning of the rise of the Ku Klux Klan. We don't need to use the state. We can use organized terrorism to enforce white racial supremacy. And then we've got Plessy v. Ferguson, right? And I think one of the reasons that the Louisiana versus Callais decision is being compared with Plessy v. Ferguson. I don't think it's as bad or as extreme as Plessy v. Ferguson, but it is the culmination of a long process of Supreme Court enforced racial retrenchment, undoing of legislation or constitutional provisions. Plessy v. Ferguson says separate but equal is not a badge of inferiority and therefore compatible with the 14th Amendment. It's not till we get to the middle of the 20th century in the Brown v. Board decision that we get an explicit overturning and right refutation of these cases that frankly eviscerated the 14th Amendment, and that the 14th Amendment, which has been essentially dormant up until this period, begins to be enforced again. And of course, in the middle of this, we get the Voting Rights Act, the Civil Rights Act of 1964. It culminates with Obergefell v. Hodges, the 2014 gay marriage decision, I'm sorry. And so there are different ways to view this period. And if you're like me, when you think of the Supreme Court, you think maybe of the Warren Court. You think of with some pride and with some admiration the really important decisions in the middle of the 20th century. But I do think part of the reason to look at this from a longer term perspective is to recognize how anomalous that period is, and not to let the halo that accompanies the important decisions in the middle of the 20th century blind us to the typical function of the Supreme Court. So very quickly, right, the understanding of what was done with these decisions from 1954 to 2014, one understanding is that it was reviving the dormant 14th Amendment protections in an era of greater support and mobilization, an era that looked like the era in which the original 14th Amendment, the post-Civil War amendments, were adopted. But another interpretation is that these were temporary measures to address abuse, and that they had, if you will, a sunset clause, right? And if you remember, I don't think I actually quoted it, but going all the way back here, that Charles Francis Adams, the son and grandson of two presidents named Adams, said in 1908, the Negro has got as much as he ought to have, right? You know, the sense that this didn't need to go on forever resurfaces in the 21st century. Another way to look at this is that this was an overextension of judicial and federal authority that fails to respect state sovereignty. And this is, I think, the way Alito and Roberts and Thomas and the conservative majority on the Supreme Court tend to regard what I regard as kind of the high watermark of Supreme Court jurisprudence in the 20th century. And so I'll just conclude this portion by saying, look, if we look at this historically, there's maybe 60, 70 years in the history of the United States where the Supreme Court interprets the Constitution as an instrument for racial political equality. That has been the exception, not the norm. The majority of our history, the better part of 200 years, the Supreme Court has interpreted the Constitution as a barrier to legislative efforts to pursue racial equality. This then brings us to the Voting Rights Act specifically. The idea that it was passed in 1965, that the two sections that were probably most important, sections 2 and 5, required, on the one hand, preclearance that the states that had engaged in racial disenfranchisement get approval from the Justice Department prior to redistricting, and also giving individuals judicial remedies if they felt that their state had engaged in racial gerrymandering or racial disenfranchisement. They could get support from the Justice Department and turn to the courts. They were legislatively empowered to sue. And when we look at this, I think from a historical point of view, the main effort of the original Voting Rights Act from 1965 was to remedy, right, the disenfranchisement of African Americans under Jim Crow, to give every citizen a vote, as the legislation put it, because the vote is preservative of all other rights. If you can't vote, every other right that you have is likely to be violated because no one will stand up for you. But then, right, the South pivoted, or states interested in racial disempowerment pivoted to other strategies, redistricting in ways that either cracked all minority voters into a single district so that they might get one representative, but they would be outvoted once they got to the legislature, or diluting them, right? This is sometimes called qualitative vote dilution, spreading blacks out over so many different districts that they were always in a minority, always outvoted. And so in the 1980s, right, there was an effort to not only reauthorize this bill, but to amend this bill to give some teeth to the enforcement of the provisions of racial equality. And the 1982 amendments to Section 2 incorporated an effects test to address, right, what the Supreme Court had done to undermine the 1965 version of the Act. This resulted eventually in what's called the Jingles test from a 1986 case, Thornburg versus Jingles, in which if, right, their racial minority is relatively compact geographically, and if there's racially polarized voting, the black people tend to vote together in one way because their interests or their identities lead them to. White people tend to vote in a different way. Then, right, the breaking up of the black people across many districts is in effect an effort to disenfranchise them, and they have a remedy to that under the law. This, right, effort from 1982 passed 100-0 unanimously in the Senate, signed by Ronald Reagan, not perceived to be a partisan issue in the 1980s, but by the time we get to the Roberts Court in the previous decade, it is perceived to be an insult to the dignity of the Southern states, to be no longer relevant. The Southern states are no longer racist, according to John Roberts. So beginning in 2013 in Shelby County v. Holder, right, Section 2, the preclearance requirement, is overturned as a violation of state sovereignty. And then to bring in another relevant case, not directly about the Voting Rights Act, but in Rucho v. Common Cause in 2019, another John Roberts decision holds that there can be no judicial remedy for partisan gerrymandering. And I'll say this very quickly. In the opinion, Roberts regrets the fact that there is no judicial remedy. Um, and by the time we get to Louisiana versus Callais, Alito is saying, well, of course, racial, I'm sorry, partisan gerrymandering is allowed. It's a perfectly legitimate thing to do. And so if the gerrymander appears on its face to be partisan and not racial, then it's permissible. And so that decision plus the earlier decision, Bronovich versus DNC, essentially eviscerates Section 5. And so now the Voting Rights Act is still on the books, but the way in which the Supreme Court has interpreted it makes it dead letter. And this is exactly what Elena Kagan said in her dissent. And I will be brief in summarizing and reading just a little bit of the dissent. Today's decision renders Section 2 all but dead letter, right? And so minority voters can now again be diluted or put all into one district. And it will have broad ranging effects in the South and outside of the South as well. And so she concludes, I dissent because the court betrays its duty to faithfully implement the great statute Congress wrote. I dissent because the court's decision will set back the foundational right Congress granted of racial equality and electoral opportunity. I dissent. And I've noted before, right, that the standard etiquette on the Supreme Court is to say I respectfully dissent, that we're getting less and less of this from the liberal minority. And I think it is because they frankly no longer respect the conservative majority. And so they're not willing to respect a decision that they believe will be regarded as something akin to the 21st century's Plessy v. Ferguson. No reason to indicate respect for people who gut important laws in this way, right? So to just now finish this portion of the analysis, I'll suggest, right, that the Supreme Court has effectively dismantled the Voting Rights Act. It is distinguishing itself as the most effective anti-democratic and racially retrenching institution in the federal government, that it's hard to ignore that this decision occurs at a moment where the Republican Party, which appointed all the justices who are in the majority in Callais, stands to lose the majority in the next election and maybe beyond that, unless the kinds of gerrymandering that President Trump and the MAGA coalition have called for, but the Voting Rights Act stands in the way of, is allowed. And at precisely this moment, of course, the court has come in to do this. I will note further that when the citizens of Louisiana sued to challenge their voting maps, they did not ask the Supreme Court to consider the constitutionality of Section 2 of the Voting Rights Act. This case was originally argued in the previous term, and rather than reaching a decision in the way in which the parties that sued asked them to, the Supreme Court directed the parties to re-argue the case, focusing on the constitutionality of the effects text in the 1982 amendment to Section 2 of the Voting Rights Act. In other words, the Supreme Court went out of its way not to decide the question in front of it, but to produce the result that it wanted to produce. And that result will result in many fewer Democrats, but in particular, many fewer African Americans being elected in the right South. And it will pave the way for a kind of arms race in redistricting, in which I think it's not far-fetched to anticipate that if Republican states go very far, as they tend to do, in drawing maximally advantageous partisan lines because they can, then Democratic states are likely to respond in kind, and this will be bad for democracy. As I've said, it is a problem for the principle of representation in democracy when the elected representatives are choosing their constituencies in order to game the political process instead of the constituencies having the power to choose their elected representatives in order to reward or punish them for legislating in ways that they approve or disapprove of. The idea that the gerrymander may not deliver immediate partisan advantage to the Republican Party, I think is worth noting, right? That the reason to oppose this is not purely partisan, but to note that when we move to this world of maximum gerrymandering, each party trying to, wherever it can, wherever it has a trifecta or complete control over the state legislature, the governorship, and the state Supreme Court, to just draw lines that favor it. The Supreme Court has essentially permitted this now. It will be the partisan incentive of both parties to do it, but please note, it's the unusual electoral system of the United States that incentivizes gerrymandering. It is the fact that we use single member, territorially based, winner take all electoral districts. And this feels very natural to us, right? The first person who wins 50% plus one represents everybody in that district. Um, but that is actually not the way democracy is organized in most of the rest of the world. And the way in which it is organized in most of the rest of the democratic world is more democratic, more responsive, more likely to produce accountability, and it does not incentivize gerrymandering in the way our system does. So that's where I want to pivot to for the remainder of today. I start with the idea that single member districts encourage gerrymandering. And just to note, right, what we have, right? And so we have a scenario here in which 40% of the electorate is red, 60% is blue, and you can draw lines on a map. Imagine, right, that this is representative of territory so that, right, it's exactly proportionate, right? So that 40% of the representatives go to the red party, 60% go to the blue party. Or you could create districts that are unfair and privilege the majority, right? In this scenario, blue, although it only has 60% of the vote, uses gerrymandering to get 100% of the representation. It is also possible to draw lines on the map, mathematically possible, right, that allows the minority to get the majority of the representation, right? And so in this scenario, right, blue, despite having 60% of the vote, 60% of the population, gets only 40% of the representation. And just to be as clear as possible, this is what happened in Pennsylvania in the last decade, right? Until the Supreme Court struck this down. But please note, the Supreme Court has now invalidated the basis on which it struck down the old Pennsylvania districting map in a scenario where, right, the Democrats got 50% of the vote, the Republicans got 49% of the vote, the Democrats got 28% of the representatives in the Pennsylvania congressional constituency, and the Republicans got 72%. Totally disproportionate representation. And by the way, right, this is something that plays out racially throughout the United States. The Senate overrepresents white voters underrepresents Hispanic and Black voters. The Electoral College overrepresents white voters, underrepresents Black and Hispanic voters. This is the consequence of the way in which, right, the Senate equally represents the states, even though the populations of the states are not equal. And then we add gerrymandering in House districts into the mix. And although this is no longer current, this is from 2017, you can see both sides do it, but that Republicans have been doing it more aggressively than Democrats, right? And so in red states, although Democrats get 41% of the votes, they only get 25% of the seats. In blue states, Republicans get 40% of the vote and 30% of the seats. I'll just pivot back to race for a moment and think about what this decision is going to mean for the future of the United States. I start by looking at what happened in the 18th century while the South was occupied by Northern troops in the Reconstruction period, when the 14th Amendment was actually enforced. The Civil Rights Act of the 1860s was actually enforced. Roughly 2,000 people of African American descent were elected to offices, and that includes a large number who were elected to state and federal offices. And you can see the numbers by states up here. This is an estimate because we don't have precise historical records. For the precise historical records, we've got at least 1,500 Blacks represented, elected to represent Blacks in the South, and those include senators, governors, mayors, etc. To look at it now in a slightly longer-term historical perspective, that's the 1870s there in terms of members of the U.S. House of Representatives. It goes up, and as soon as the Northern troops leave, as soon as Reconstruction ends, it goes back down, and by the way, it goes to zero for much of the first half of the 20th century. It then begins to increase marginally until the Voting Rights Act of 1965 is passed, and then please note it goes up quite dramatically to the point where things are essentially proportionate. Roughly the same number of Blacks are in Congress, percentage-wise, as there are Blacks in the American population. Very quickly, right, we are becoming a more diverse society. Everywhere on the map where there's a blue arrow pointing to the right, you have greater diversity of the population. If you can see a few red arrows, that's where the population actually became more white, not happening many places, right? And please note, right, that as we go through time, the proportion of the population that is white shrinks, the proportion that is Hispanic grows, the proportion that is Asian grows, and the result is that pretty soon, as we are seeing in almost every major American metropolitan area, the country as a whole will be majority minority, or there will be no racial majority by the time we get probably to 2045. That although, right, we have seen, right, when the Voting Rights Act is amended, African Americans obtain something akin to proportionate representation in the House of Representatives, primarily because they gained representation in the South because they were no longer able to be disenfranchised. We've also seen polarization in this country of racial views. And in particular, right, most Americans don't think it's a particularly good or a particularly bad thing that we're becoming more diverse. The number of Republicans who think it's bad is still quite high. The number of Democrats who think it's good is quite high. The number who think it's bad is quite low. So, right, inverse relationship between the evaluation of the growing diversity between the two parties. And please note, white liberals no longer think that immigration is a problem, right? White moderates, a little bit more of a problem. White Republicans or conservatives think that it is definitely a problem. And this is reflected then in the demographics of the party. The Republican Party still remains an almost entirely white party. The Democratic Party essentially mirrors the racial demographics of the United States. And by the way, Donald Trump's electoral magic seems to be primarily accounted for by his ability to attract voters who feel hostility to blacks, to Latinos, to Muslims, and to gay people into the Republican fold, right? So this then is the deeper background to the question about, as we become a multiracial society, will we successfully become a multiracial democracy? And I hate to say it, but if we stay on the path we're on, we're all but certain to fail that test. And in 2026, I hope the evidence is clear. We should not rely on the Supreme Court to help us get there. And by the way, then if we continue on the path we're on, if we continue voting in the way we vote, if we let the smaller, whiter states have disproportionate impact on our politics, veto whatever efforts we might embrace, for racial equality, then we will not successfully make the turn to multiracial democracy. So, what can we do? And here I want to suggest a couple measures that do not require constitutional amendment, abolition of the Supreme Court, expansion of the Supreme Court. Look, I agree with Chemerinsky. I agree with Bowie. We ultimately need fundamental institutional reform, but as polarized as we are right now, I think it's impossible to imagine that happening. So what could we do? Well, I think one thing that we could do right away, and that might just have bipartisan appeal, it might not, but expand the House of Representatives. Note, right, we did that almost every decade from the founding to the beginning of the 20th century, because as our population grew, in order to maintain accountability, in order to maintain constituencies that were compact and homogenous, we recognized we needed more representatives. But beginning with the beginning of the 20th century and to the present, we have not expanded the House of Representatives. And the result is that we are a deep outlier in the proportion of our population to the number of our representatives. We should fix this. And if we fix it, we will have less pressure to gerrymander. But the deeper fix, and this is the one that I really want to conclude with today, is to move to a different kind of electoral system. And here I'm going to suggest that the most important reform would be to move away from single member, winner take all, to multi-member, proportional, ranked voting districts. So right now, Texas has 33 districts. If Texas were instead to have maybe 10 districts, and most of those districts were multi-member districts, on the one hand, right, it wouldn't be the case that where you lived determined whether you got representation or not. Everybody in these larger districts would probably be able to vote for somebody who won the election. And so one way this is expressed in the literature on voting is winner-take-all elections create very low thresholds of exclusion, right? If you get only 49.9% of the vote, everybody in that 49.9% is excluded. Whereas in these models, very often some right party or group that has 10% of the vote can get representation. And it's not just that it wouldn't exclude as many people, it would deeply remove the incentive to gerrymander, to redistrict in partisanly advantageous strategic ways. And by the way, it would also increase democratic accountability. It would eliminate the need for primaries. It would create better representation, better democracy in the United States. And so I do think that part of the challenge of this recent Supreme Court decision is for us to be able to say we deeply disagree with this decision, but we're not just going to sit around and wait for the Supreme Court to fix it. We're not going to sit around and wait for there to be Supreme Court reform or a new Voting Rights Act. That's too long. This is too important. This is the heart of our democracy. We need to figure out ways to do things now. And by the way, states like California, New York, our liberal states, should begin experimenting in ways that demonstrate to the rest of the country, if we reorganize our elections, we improve our democracy, and let us hope that that would be something that might appeal even to our partisan adversaries in other states. I'll stop there. That's the argument I wanted to make with you today. I know I went fast to try to get everything in. Please let me know what questions do you have? Do I need to better explain things? Are there other ideas that you have? Want to hear what you have to say. Who wants to start us out? Stunned silence. What do you think? Are you ready to start lobbying for electoral reform? Yeah, Barbara, go ahead.
Well, ranked choice voting exists in large parts of California, and it is routinely A, misunderstood and B, hated. Alaska has a very different system that, from what I've heard, works way better than California. So, probably the thing California should do best is rethink the way they have it. There are 62 people running for governor.
Yeah, yeah. No, ranked choice voting for Congress in a multi-member district is very different than
Right.
ranked choice voting for governor, where there's one person you're trying to choose for the whole state, right?
No,
And so please note, right, Lisa Murkowski is in the Senate only because Alaska has ranked
right.
choice voting, right? And you know, she ran as an independent, right, when she got primaried from the right, and you know, said, okay, I'm not going to be the Republican. I think I still better represent the views of the people of Alaska than does my far right MAGA competitor, right? And by the way, there's some chance that a Democrat will win in Alaska this right time round, in part again because there's ranked choice voting. So yes, you got to do it right. You know it, and I will admit, right, part of the issue here is that we're very familiar with the system we have, right? It's kind of like the healthcare debate. Everybody wants healthcare reform, but everybody wants to keep their doctor and their insurance, right? You get used to the system you know. And the transition can be difficult. But having said that, I do think that our system is so dysfunctional and the Supreme Court is so radically maximalist and supremacist and frankly so committed to retrenchment in its politics and its judicial theory that we've got to find ways to work around it. And if we don't, we may end up with what Wright Chemerinsky defines as permanent minority rule. So yeah, I know it's not easy, but I think it's worthwhile pursuing the reform and doing it in the right way. Thank you, Barbara. And I do know that you guys are about to have an election, right? And it is kind of confusing right now given the range of candidates. Barbara, I'm sorry, Ann, go ahead.
Yeah, well, you end up with saying, we really need to do something about it. My point is, how the hell do we get started?
Yeah. Yeah. So who's the we, right? That actually does something.
Yeah.
And here I will note, and I think this is part of the difficulty, right? The system that we have functions very poorly for almost everyone except for the two main parties, right? And fortunately, there is a kind of incumbents inertia in which the two main parties know that they are going to continue to monopolize political power, to make a lot of money in terms of campaign financing under the current system, and they don't have much of an incentive to change it. So yes, I do think, and please recollect the images, um, the first two images I showed you, right? Of mass marches during the civil rights movement. This is not going to happen because, right, of good government books being written or bills being proposed. It's going to happen only if the people are angry. And I do think, one of the questions is whether or not that anger gets channeled in a constructive or a destructive direction. And I think the battle in the United States right now is between people who are angry at the system and therefore seeking ways to reform it, and people who are angry at the system and therefore seeking ways to use the current system to maximum destructive effect. And so yeah, unfortunately, I think the Republican Party has got out ahead of this, has become primarily an engine of populism, of nativism, of exclusion. And if the Democrats don't catch up, we're not going to be very happy with our politics in the middle of the 21st century. So, Anne, yes, I share your frustration. I wish I had the silver bullet answer. I don't think there is a silver bullet answer, right? The reason we got reform in the middle of the 20th century is that for the previous 50 to 70 years, people patiently organized in the progressive movement, in the labor movement, in the civil rights movement, in the women's rights movement. And it's a long term heavy lift to organize the people to counter the vested interests, the strength of the parties, the settled ways of our institutions. There's no easy way to do this. How's that for an uplifting idea? I'll just add very quickly, by the way, they succeeded in the middle of the 20th century. And so it is possible to do this. Flossie, it looks like you're raising your hand. Go ahead.
What I remember about Mr. Alioto was that, correct me if I'm wrong, when Obama was making his inaugural address or addressing the country, um, it was Alioto who barked out, "You lie."
So I don't think you're remembering that correctly, Flossie.
Thank
And I think you mean Alito, who is the Supreme Court justice,
You're right.
right?
Alito, God, not Alioto.
Yeah, it's okay. I know who you're talking about, but what happened? So there is a member of Congress who, during Obama's State of the Union address, blurted out, "You lie." But actually, that's different from the incident I think you're referring to, but it's similar, right? I understand how we get our wires crossed on these issues. During one of Obama's State of the Union addresses in the immediate aftermath of the Citizens United decision. And really, this is the first of these decisions that is so hostile to, I think, the American people's capacity to actually use their vote to determine how they'll be represented, right? So Obama says he thinks that the Supreme Court made a major mistake in that decision and that it will be bad for democracy. And Alito shakes his head vigorously no, right? And it was seen as a violation of decorum, right? That the Supreme Court justices are supposed to sit impassively while the president speaks. Um, and perhaps it was telling, right? Please remember Alito's wife raised an upside down flag in the aftermath of Joe Biden's victory. So if we're talking about partisan displays that seem to violate Supreme Court decorum, Alito's a pretty good candidate. But I think it's just telling of the fact that, in particular, the conservatives on the Supreme Court are the products of a patient, long-term, very expensive campaign organized originally by the Chamber of Commerce and then by the Federalist Society to remake the federal judiciary in an ideological and frankly partisan mold. And Alito comes out of that, and Roberts comes out of that, and Thomas comes out of that, as do obviously the three Trump appointees who were handpicked for him by the Federalist Society, right? And so yes, and by the way, if you look at Elena Kagan, especially in ways I've quoted to you before, if you look at Ketanji Brown Jackson's decisions, they too are increasingly partisan. If you look at the approval of the Supreme Court, it's almost as low as the approval rating of Congress or the president. And that's because it is widely perceived to be a partisan institution right now. And so, yeah, Alito wrote a decision
Well,
that I think many people will regard in the future as a truly awful, nakedly partisan decision in this case. But I think it's time to in a sense, just disabuse ourselves of the notion that we should expect better from this court. This court has shown us who it is, what it is, and we now know what it's going to do for the foreseeable future. By the way, it's likely that Donald Trump will get another appointment or two to this court. Let us hope that it's a conservative who resigns as opposed to a liberal who dies when Supreme
oh
Court.
my God, oh God, yeah.
But this is where we are, and we have to face it, right? Without right illusions. We cannot rely on the Supreme Court as an anti-democratic institution, and for the foreseeable future, we have to find ways to work around it.
Yeah.
Yeah, that's where I am. I'm sorry to be so blunt. I know that for many of us, the aura of Brown v. Board and Roe v. Wade and all of the great First Amendment jurisprudence makes us want to think this is the institution that stands up for our rights and our claims to equality. And I'll just add, I really believe that there is a world in which it makes sense to have a high court protecting a constitution. But given the constitution we have, given the court we have, given the world we live in, we're not living in that world.
And I want to apologize for confusing Alito with Alioto.
Apologize to the memory of Alioto. Yes, yes. Yeah, I knew immediately what you were saying, Flossie. No need to apologize.
Well, that guy, Mr. Alioto, was a gentleman, and when we teachers were going on strike, he addressed the strikers and and saying to them, "Leave it to me. I will take care of you." Well, he did after a fashion. I think we won the first strike, but we kept losing the other ones. So there is a real need to face reality. Our dreams are things to hold on to, but it takes guts to make them come true. We
And
have to fight.
yeah,
We,
thank you for that, Flossie. Joseph Alioto, of course, was the mayor of San Francisco. Was that in the 1980s, I want to say? But yes, I knew who you meant, and it is an easy wire to cross. And he was, I think, in most accounts, a decent
Okay.
mayor. Um, I think that's a good place to leave off for today, unless there's an urgent comment before we go. Be well, everyone. Take care. Nice being with you as always. These are
Thank
important
you.
topics. I'm glad to have the opportunity to test out ideas with you and to discuss them with you. Thank you.
Thank
See you
you.
next week. Bye, everybody.
Thank you,
Bye.
David.
Thank you.
Thank you, David.
Pleasure's all mine. Take care, everybody.
Thank you.